Okay, so welcome again to Health in Europe. This is the first of the summer season. Today, what we're focusing on is the future of EU health law and policy. And I'm just going to start introducing this. The future of EU health law and policy is the title of a special issue of Health Economics, Policy and Law, which came out a few weeks ago, and is a special issue which is devoted to the project EU Health Law and Policy Shaping a Future Research Agenda. So this was a British Academy project that Dr. Eleanor Brooks and myself ran between 2018 and 2020. So that's, in a sense, I've tried to put the whole project on a slide, which was perhaps a bit ambitious, but you can see there we've got our funding sources, our respective institutions, our original Twitter feed. In addition, we had 2 dedicated project workshops, one at Lancaster in April 2018 and one in Edinburgh in November 2018. We also presented work at international conferences such as the University Association for Contemporary European Studies, UACES, Society of Legal Scholars, and we also presented over at Maastricht as well. So the Lancaster workshop was an innovative approach, really, Ellie's brainchild of having a World Cafe format. As you might be able to see with the picture on the screen, we had a conference room here at Lancaster set out with bunting and in small groups to facilitate small group discussion of research challenges in the field of EU health law and policy. And we invited people to submit these for discussion. So we had a range of subject areas, firstly characterising what we mean by EU health law and policy, but also aspects such as patient rights, health in all policies, pharmaceutical sector, European semester, and very briefly, Brexit. From this, we were able to distill some of the outcomes into an outcomes document. It's still available on SSRN if you're interested in seeing how those discussions unfolded. And it helped us identify particular areas which were then picked up in the Edinburgh workshop later that year, and it's the papers mainly from the Edinburgh workshop which you find in the special issue. So I'm going to hand over to Ellie now to talk a bit more about the project.
Thanks, Mary. So I'll just try and say a little bit about the context, I suppose, that we were working in around about the time, and I was trying to reflect yesterday on the situation that we found ourselves in back when we were stringing up bunting in 2018, and it was quite different to the one that we have now. I think the important thing is to say is that we were concerned about the political context. That was what brought us to put in the application for the funding in the first place and to bring together the special issue. You know, that context was somewhere towards sort of midpoint, I suppose, of the Juncker Commission, of the presidency of Juncker at the time, who'd shown a relative disinterest in health. We were amidst rumours about the future of DG Santé and whether we would still have a health directorate by the end of that term, or whether it would have been sort of disbanded and distributed across other directorates within the Commission. And the white paper, of course, which essentially foresaw an end effectively to EU action on health altogether. So we had all of these sorts of things going on in the background as we were putting in the application, and that was affecting, I think, the breadth of topics that people were interested in, and the impacts of those dynamics upon what was happening in people's particular policy areas of interest, I guess, was quite crucial for informing the shape of the final special issue. By the time we were putting the special issue together, though, and we were meeting more regularly sort of around publication schedules and things, there were already some signs of change. So Stella Kyriakides, the new health commissioner, her mandate's very different to the one of her predecessor. She's been given a much broader role, and a lot more was said about health in the run up to the von der Leyen commission. And I think there was much more optimism at that time about what we might see as von der Leyen came into office. A lot has clearly changed since then, but I think this is a really nice opportunity, and I'm glad that we have this opportunity to get together and reflect a little bit on what was preoccupying us before the pandemic hit, because all of that is still important now, albeit in a slightly altered context. I think it's really interesting to reflect on what we were all talking about before, the changes that have come about since the end of 2019 and the start of 2020. To the special issue itself, so we're lucky and thrilled to have a whole bunch of the authors here, and I'll hand over to them in a minute to present their papers, but I just wanted to say a little bit about the contributions that we have where people weren't able to to join us to talk through. So Anya Naumann and Ollie Bartlett submitted a wonderful paper looking at the health in all policies principle as the first one to mention. And what they do there is unpick Article 168 and what led to the health in all policies principle in the first place, and look at the problems with enforceability. And what they conclude there is that we need not only to think about a slightly more precise interpretation of Article 168, but also the role of soft law in the EU. And I think there's a lot in that paper that speaks to the much broader debates on soft law in European policy, and the potential for those sorts of instruments, for soft instruments, to be adjudicated by the court, and how that might work and affect our ability to enforce the health in all policies principle. So that's one that I wanted to mention. The second is the paper by Holly Jarman, Sarah Rosenblum and Tiffany Huang, who co-authored a paper on the Medical Devices Directive. Super paper reviewing the way in which that directive was revised. It draws some slightly concerning conclusions that we continue to see a prioritisation of innovation and corporate interest over the need to protect health within the sort of regulatory structures of the EU. Essentially, that is a case study in a way, I think, of Anya and Ollie's paper, in that it's saying, look, actually, the EU continues to fail to implement this mainstreaming principle, and the result of that is this imbalance between regulation and health protection. The most worrying conclusion, I think, is that the revision of that directive is simply not doing enough, not least in that it continues to leave oversight and regulatory oversight to private actors, and that we're likely to see the same threats to health and damage to health even at an individual level under the new regime. The final thing then for me to mention is probably in our short postscript, Aniek de Ruiter, who is here and will be able to speak a bit more to this in the Q&A, I'm sure, if anyone has questions. We have the pleasure at the end of reviewing these papers for our short postscript, and of doing that sort of in the context and with some hindsight a little bit, I suppose, from the pandemic, because we were right at the end of the publication process and the papers had all been finished, and we were able to review them and reflect a little bit about what COVID-19 might mean for the findings within those papers. So we build in the postscript a bit on the core questions about the role of the EU in health, and discuss challenges around sort of four main themes: so Europeanisation, globalisation, digitisation and technological change. And we look at those as sort of new starting points for the research agenda. But the conclusion that I wanted to pick up on here is what's important, we decided from the perspective of us as a research community, is that we have to take the multi-level and the multidisciplinary challenges that are identified in all of the papers in the special issue as a starting point. We have to conceive of EU health research as something that involves folks from political science, folks from sociology, the lawyers, the public health folks, the global health folks, but also people who would normally or naturally focus at the national level, the EU level, or the global level, perhaps separately, and just acknowledge that actually as a starting point we need to all be working on the same problems, rather than sitting, as we have perhaps tended to do in the past, in our silos a little bit. So that was the overall conclusion that Aniek and I had the pleasure of drawing after all the papers had been written. I'm very optimistic that the networks and the projects and the things that people have got going on that we hear about quite often through this lovely seminar series are well placed to help us act upon that and continue all working together. But for now, I think in the interest of time, Mary, you are right with me handing over to the first of our author speakers, and we'll, okay, super. Thibaud, are you around to say something about your fabulous paper on the ECDC? You are on mute, my love.
I keep on being on mute today.
No trouble, the floor is yours.
I was actually thanking you for organizing this. It's really awesome to have this this tribune and this research community. So yeah, today I'm going to talk about this paper that is actually not just about the ECDC, but about 3 agencies and their work on regarding the fight against antimicrobial resistance. Antimicrobial resistance is a very important problem, but not as salient as another very important problem we're facing today. It is, however, related to this problem to a certain extent. It's very much a problem that is about both human health as well as animal health. And this problem of antimicrobial resistance has been a flagship policy of the EU for quite a while, actually, even though a relatively silent one. So since the 2000s, we have actually had this this turn in EU health policy, and it's a turn that coincides with the One Health turn. The One Health turn, that is this all-encompassing turn where you look both at human health, animal health, and just the whole biosphere as one thing that is quite coherent and that may have repercussions on its different parts. So in the EU, of course, the Commission has been very proactive since the 2000s regarding AMR. And since the 2000s, actually, there's been very interesting developments regarding 3 agencies. So the ECDC, the European Centre for Disease Prevention and Control, EMA, the European Medicines Agency, and EFSA, the European Food Safety Authority. And nowadays, those 3 agencies are producing cutting-edge research regarding the evaluation of the scope of AMR, antimicrobial resistance in the EU, especially the JACRA reports, which are those big reports that come out every couple of years regarding the state of AMR in the EU. It was very interesting for me to look at how those agencies would actually work and cooperate together. Why? Because those agencies actually have very different powers. In the EU, agencies are not regulatory per nature. They can be quasi-regulators, but in our population of agencies, we end up with, on the one hand, 2 gatekeepers, EFSA and EMA, which are really trying to prevent bad products to end up on the market, and ECDC, which is only allowed to do surveillance. So the big question I was asking in this paper was, how are the tasks and roles ultimately assigned in this sort of cooperative governance of AMR? For this, I relied on this paper on reputation and uniqueness. The literature on reputation and bureaucratic reputation in particular has been very adamant regarding the importance of uniqueness of agencies, the ability to bring something unique to the table, to show a unique role in the fight against AMR. And from the beginning, actually, the distribution of roles was not, so to say, very transparent. It was not very clear. How would those 3 agencies actually cooperate was not a given, especially in the 2000s. Considering that agencies are likely to want to protect their uniqueness, are likely to want to protect their role within a given area, this was really interesting to look at it from a reputational perspective. So this paper is based on narrative analysis, the narrative of 3 agencies, each agency having their own narrative of this cooperation throughout these years. And I will not go back in the historical parts of the paper too much, but let's say that at the very beginning there were early turf problems between agencies, and turf problems that are interestingly related to also the professions which are represented in those agencies. Basically, in the 2000s, we had a blame game between the human health part and the veterinary part. Some of them, human health, of course, blaming the veterinary part for pushing antimicrobial resistance and vice versa. The 2000s were complicated in that regard, and it was especially complicated between EMA and ECDC, simply because other turf problems occurred at this point between EMA and the ECDC, especially regarding the H1N1, the swine flu crisis. So, of course, all those things are related when it comes to those agencies because they are dealing with those different topics at the same time. But because of the mandate of the Commission, those agencies have been led to cooperate much more with one another, and especially cooperate in setting up or at least fortifying scientific networks. Each agency is actually at the head of different networks, sometimes 1, sometimes 2, that are either actually doing surveillance regarding antimicrobial resistance or surveillance regarding the consumption of antimicrobial antibiotics. Sorry. What do we have today? And in order to keep it short, I will end with this. What do we have today? Today we have a very interesting division where human health and animal health have been sort of separated in spite of the One Health approach. Of course, there's still a lot of cooperation between those agencies, but the roles are much more clear. So for animal health, it was a given that it would be EFSA. EFSA, the Food Safety Agency, would be, of course, very interested in the health of livestock and so on. However, for human health, there was a problem that was persistent over the years between ECDC and EMA. Interestingly, today, ECDC is the agency that is actually dealing with human health, when EMA is actually dealing with animal health. This is interesting for different reasons. First, it is interesting to see that the two gatekeepers are now teaming up, so to speak, in animal health. Animal health is easier to deal with in the EU. You can relate it to the market much more easily than human health, and we've seen that in the last couple of years, almost now. ECDC therefore has taken the lead on human health. It is now helming, it has been helming for almost 15 years, the European Antimicrobial Awareness Day. And on the other end, EMA and EFSA are producing seminal reports called the RoNAPFA reports, which are nowadays sort of the Bible when it comes to veterinary care. So overall, the story of this cooperation is interesting for those turf problems that occurred at the beginning. Turf problems, especially between EMA and the ECDC. These, however, are also signs that are quite important when we think today about the future of health threats governance. Things are not set in stone. There are many developments happening at the moment due to COVID-19, but we have to keep in mind that cooperation between agencies, cooperation between different organizations, especially with different levels of competences, especially with different approaches, sometimes professional, sometimes just vis-a-vis procedures, are important, and we need to keep them in mind in order to foresee this future for health threats governance. So that's it. Thank you.
Thank you very much, Thibaud. So we're going to follow that now with a bit of a change in direction, which is to say towards competition law in healthcare. So this is the paper written by myself and Professor Johan van der Gronden of Radboud University, Nijmegen. I'm just going to talk a little bit about how we structured the paper before handing over to Johan. So the paper in part reviews, if you like, the state of the art as regards defining the parameters of the EU competition law framework in the healthcare context. But we use that as a sort of starting point to examine a test devised by Johan based on state aid case regarding Spanish educational establishments, and in the paper we apply that test to the healthcare context for the first time. So by way of background, when we think about applying EU competition law, that is the trigger requirement of an undertaking, and if you like, the classic definition of this is an economic activity, which gets further defined as offering goods or services on a market. So that would seem to suggest a particular direction, that is to say, a providing side than a purchasing side to a transaction. So, and what we see from various cases is a kind of distinction emerging between healthcare providers being subject to EU competition laws, such as the Pavlov case or Ambulance Gluckner with regard to ambulance services, and healthcare purchasers typically being found not to be subject to EU competition law. For example, in AOK Bundesverband, this case related to German sickness funds. In the Spanish FENIN case, this was concerned with purchasing bodies in the Spanish national health system, with distinctions emerging between sort of upstream and downstream activity, and the idea of the purpose of purchase coming into play as well. So those cases were sort of 2004, 2006. More recently, we've had DZP, UZP, which looked at health insurers in Slovakia, so state insurers and also private insurance companies as well. And at the time we were writing the paper, the DZP, UZP case had gone from the Commission, who decided that competition law didn't apply to Slovak health insurers, so essentially following previous approaches, and that had been appealed by private insurers to the General Court. And the General Court had found, interestingly, that competition law did apply in this context. Subsequent to our submitting the paper, this was appealed again to the Court of Justice, which appears to have effectively reinstated the status quo. It followed the previous case law and found that competition law didn't apply to purchasers. So we get this distinction coming out between providers and purchasers. Another aspect of the EU competition law framework to bear in mind from a healthcare perspective is the services of general economic interest, SGEI exception, and the sort of partial immunity from competition rules. So both antitrust rules, the prohibition on anti-competitive agreements and abuse of dominance, and also the state aid rules. There can be partial immunity if an activity is classified as an SGEI. So it's effectively saying, yes, there's an economic activity, but the activity is classified in this manner, which gives rise to particular distinctions. In the ambulance Glöckner case, we see a distinction being drawn between standard patient transport services being subject to competition law and emergency ambulance transport classified as SGEI, for example. In the paper, we also look at a Dutch case, Urgendia and Ministry of Health, Wellbeing and Sport, which involved a Belgian company challenging a state aid payment to subsidise discounted provision of prenatal screening tests in the Netherlands. So that was just to give an overview of the EU competition law framework, and I'll hand over to Johan now.
Mary, I'm just going to jump in because I'm not seeing your screen anymore. I'm seeing someone else's. I think it's, yeah, I think Kristin's right. I think it's Laura. If you're able to stop sharing, I'm not sure how it's happened, but somebody's managed to. Right, that looks better. But Mary, your slides have disappeared. So if you could start sharing your slideshow again.
No problem.
Thank you. I'm not sure what happened. It got a bit confused.
Okay, can you see?
Super. Yeah, that's perfect. Well done.
Familiar. Okay. All right. So over to Johan.
Okay. Thank you very much, Mary. Indeed, we explored the concept of undertaking, and we discussed and explored the cases of the past. And we found that actually, when it comes to the concept of undertaking, two tests are deployed by the court. The first one is a kind of abstract test, which is applied normally to healthcare providers. And the court, as a rule, finds that healthcare providers are engaged in economic activities for the sole reason that they provide service and goods at their own risk. It's a rather simple test, and it only requires a couple of lines from the part of the court, and then it moves on to applying the competition rules. When it comes to the bodies managing social security schemes, including healthcare schemes, the test is way more sophisticated, and it depends on the actual design of a particular healthcare scheme, whether the body managing the healthcare scheme is regarded as an undertaking for the purposes of competition law. And the court will explore the role of solidarity and also state control, whether indeed the state tries to ensure that the solidarity principle is complied with in practice. So the concrete test enables the court and the competition authorities to take into account solidarity and specific features of a healthcare scheme, and that's not possible under the abstract test. And you could say the abstract test is a kind of simple, and therefore we ask, probably could you move to the next slide, Mary? We asked the question whether this test had to be adjusted, had to be changed. And as Barry already said, we draw inspiration from a case dealing with educational activities and with state aid, which is the CEPB case. It was handed down in Spain. It concerned a Spanish case. And what was at stake here in this case? There was a primary school received some tax benefits from the government, and the question was whether these tax benefits amounted to state aid. And at first, of course, the court had to examine whether the primary school was engaged in economic activity, should be regarded as a undertaking. And in order to do so, it took a look at its own free movement law cases. We have had in the past a lot of free movement law cases on educational activities and free movement of services. And it found that if a particular activity is predominantly financed by the state, the activity concerned is not of an economic nature. And in contrast, of course, if an activity is predominantly financed by private means, of course, the activity concerned is of an economic nature, and the school performing these activities is an undertaking. And this was kind of recycled in this competition law case, so we could indeed find some kind of convergence taking place in competition law and free movement law. And the court said, well, when the activities of this primary school in Spain is predominantly financed by public means, it's not an undertaking, because in that case, the state fulfills its social, cultural, and educational duties towards its population. And insofar activities are not financed by the state, of course, this is an activity of an economic nature. At the end of the day, let's say the core activities were found not to be of economic nature due to public funding, and some kind of ancillary activities, additional activities, were not financed by the state, and for that reason, competition applied to that category of activities. And we asked the question, why does public funding play such an important role in this case, in the cases dealing with educational services and competition law and free movement law? And we would say, well, the thing is that the provision of the services concerned, the supply of the service concerned, is mainly depending on the financing of the state, on public funding. Without public funding, the services concerned or the goods concerned will not be supplied on the market. And if you reflect on that, you will see that actually solidarity is engaged, because you need the money of the taxpayer in order to ensure that, let's say, primary school activities are performed on the market, to ensure indeed that children are taught and are trained for future. So I would say that the principle of solidarity plays an important role here, and for that reason, in this case, CEPB, you could argue that the role of solidarity, the principle of solidarity, justifies that competition law did not apply. So, in our view, this was a very important finding, and now we are at the next slide, because it will. I don't know. Please go back. I'm sorry, I made a mistake. Okay, my fault. Sorry. Okay. That's a very important finding, I would say, because this finding enables us to incorporate, to introduce elements of solidarity in the abstract test. The test as it stands right now doesn't leave room to any kind of considerations related to solidarity, which is now possible, and for which kind of test should be developed in order to find that healthcare providers are undertakings for the purposes of competition law. So we argue that the test of CEPB, which concerned educational activities, could also be used in the area of healthcare, also in the field of healthcare, because also solidarity is of great importance when it comes to healthcare. And how should such a test look like? If we take a close look at the judgment of the court, and we found three important conditions. The first one, as we already said, is that the supply of the service goods concerned are mainly depending on public funding. Without public funding, the activity concerned will not be performed. So it's mainly depending on that. But that's, I would say, only one step. We also have to take another step, a step which is related to the rule of solidarity, and therefore we brought in the attainment of the objective of public interest. So this public interest objective, objective is of course closely related to solidarity. It's important that those services are provided in order to achieve a general interest objectives. And the third one is that these activities which are financed should be closely related to this objective. And if this is possible, if this test will be applied, we could find that some healthcare providers, which are now regarded as undertakings, will not be regarded under this test. And for what reason we do think that it is important to change the test and to, let's say, carve out some healthcare providers from the scope of the competition rules? Well, I think it's based on a simple view, a straightforward view. If no market exists, it does not make sense to apply competition law, because competition law at the end of the day is the rule of the game for competition, for markets. Competition law is about the rule of the game for markets. Just to give an example, suppose that a service will only be provided if it is financed by the state. It's a kind of pointless bureaucratic operation to at first notify this funding to the Commission. Then the Commission will check and find out that without state intervention, the service concerned will not be supplied. Things was of added value, and then at the end of the day, the Commission will approve this state intervention, this public funding. But for what reason was this case sent to the Commission anyway? Because at the end of the day, no market exists, and why should we apply, for instance, the state aid rules to a case which doesn't involve any market forces? And therefore, probably could go to the last slide, the conclusions. We think that this new test we propose does justice to the special nature of the activities of healthcare providers. The concrete test dealing with the managing bodies already do so, and I think this may be the added value of the test we propose, also to enable the competition authorities and the courts to take a close look at the special features of healthcare providers, rather than drawing a simple conclusion based on a very simple test. In our view, solidarity plays a very important role. Solidarity is a reason not to apply the competition rules, so that's important. And that's the way I would like to end, is to again draw your attention to the concept of service of general economic interest. It will still be an abstract test, so it means that if a particular service may be provided on the market, with some kind of viable business case for providing particular service, the conclusions will be indeed that competition law applies. And then, of course, again, the question arises how to strike a balance between healthcare objectives, social policy goals on the one hand, and competition and market forces on the other hand. And I think that the concept of the general economic interest is a perfect concept for striking this balance, which was already pointed out by Mary. So this is what we would like to say, and we're looking forward to your comments on our paper and your critical reflections. Thank you very much.
That's great. Thank you, Johan. Yep, we'd certainly welcome feedback on the new approach to competition law in the healthcare context. Okay, so our next speaker, I'm afraid the special issue jumps around in terms of topics. We welcome Dr. Kristin Edquist from Eastern Washington to tell us about her paper, EU Mental Health Governance and Citizen Participation, a Global Governmentality Perspective. So the floor's yours, Kristin, and please let me know when you want the slides moving on.
Okay, great. Thank you, Mary. Okay, so you have the exact slide presentation I sent you, correct?
Yeah.
Yeah. Okay, good. Great. Thank you. Okay, so thank you very much for inviting me here, and I've really enjoyed working with Ellie and Mary on this project. This project is a little bit different than the last two that you've seen presented, in the sense that it's more of a critical reflection on previous scholarship regarding EU mental health, which has been, and health policy general, and the scholarship on EU mental health is quite thin. So I believe this is one of my contributions, which is simply to sort of lay out the fact that the EU, yes, has had an EU mental health governance process, although it's either paused or ended, depending on the new commission. But it's a very interesting case that I knew about when I was reading scholarship that was expressing a lot of optimism about the opportunities offered to not only healthcare providers and psychiatrists, but also citizens themselves and activists regarding the soft law in EU health, and even in one case in EU mental health. So I wanted to sort of critically reflect on that, and thus the central questions of my paper include: how did EU mental health governance operate, and what was the structure of the political relations, especially opportunities for citizen participation within EU MHG. Next slide, please. So what I did was, instead of, so I adopted a more skeptical approach, which is the global governmentality approach. And this approach required me to reconstruct the history of EU MHG as a policy area, and in doing so, focus on practices and discourses that structure the political relations amongst stakeholders. Next slide, please. These are some of my findings, and I'll go through a few of sort of the structure and the history of, in just a second, but I wanted to provide a preview here. One of the things that I knew going into this was that the EU MHG had a transnational dimension, and that transnational dimension included not just European states and psychiatrists and policymakers talking to each other, but also larger transnational dimension that included participation of international organizations like the World Health Organization, even the World Bank, and some of its practices being incorporated into EU MHG. And I list here some of the main practices and discourses involved: deinstitutionalization and community mental health, which preceded EU mental health governance, and began in both the US as well as Italy and France way back in the 60s. New public management, which is of course a sort of a practice of policymaking that originated in the capitalist sector, in business. And that also preceded EU MHG, but was, of course, implemented very strongly, especially with the rise of new soft law, although soft law is not necessarily new public management. And another transnational discourse and practice was risk thinking in psychiatry. And I'll talk a little bit more about that in a minute. So the EU MHG shifted focus over time. It started out really as viewing mental health and mental ill health as public health issues. But then around 2008, 2009, it started to focus more on mental ill health as a risk or a burden to societies. And this was a very important shift because I think it's very important to consider today, given that we're facing an enormous public health crisis, including some people are arguing mental health as a public health crisis. A semiotic system, I'm calling it, basically discourses, sort of a sea of discourses within EU MHG emerged and defined common sense policy, excluding some things like the fact that mental health might be a public health issue. And within this, NGOs, which were a very important part of helping to shape EU mental health governance, but also become conduits of it, becomes very clear. And because of this, in parts, I argue that citizen participation in input into EU mental health governance really was discouraged. NGOs were treated as proxies for citizens, but they are not citizens, and the NGOs' participation itself was heavily conditioned by this semiotic system. Next slide, please. So this is simply, I'm not going to walk through all of these, but this is the essential, these are the central decisions made at EU level regarding mental health. As you can see, it started around 1998, and the entree is the Amsterdam Treaty, Article 152. There were other legal justifications made over time as the treaties were revised. Also, the World Health Organization was, and its impetus on mental health, especially in 2001, was really important. But this was the public health element, and over time, when we get to the 2008 high-level conference, and the Pact for Mental Health and Well-being that was produced out of that conference, the focus is not on sort of a global no health without mental health, but rather focus on particular disorders, mental health disorders. With that new approach, member states built some policies, joint actions. These are all soft law policies, of course, joint actions, framework for action, and then the compass for action. And EU Compass was the final element of this first round, I would hope, of EU MHG. And as of 2018, when I went to an EU Compass conference, there was lots of skepticism as to whether the Commission would actually renew the budget for mental health. And indeed, it did not renew any specific focus on mental health. Next slide, please. So this is simply an attempt to capture, I'm not going to walk through all of this, but EU MHG as a semiotic system. It encapsulates parts of deinstitutionalization and community mental health centers, but those are only part of it, and that discourse preceded it. New public management, which is the process of using indicators and benchmarks, good or best practices, partnerships, consultation. Those are all very important elements of EU MHG that persisted. And then risk thinking, which includes the concepts of burden of disease and disability adjusted life years. Those sorts of concepts that were developed at the World Bank are used and continually used to talk about mental ill health as a burden and a cost to society, which I think is a very important discourse about mental health at the EU level. Next slide, please. This is an attempt, and this is my attempt, I was reflecting on this last night, to depict citizens' relationship to this whole semiotic system. I was frustrated because PowerPoint wouldn't allow me to capture it the way I wanted to, and I thought, well, I'm stuck in a semiotic system here that I can't access the way I want to. So in this case, really what I'm trying to show is that EU mental health governance encapsulates much of this. Global institutions are part of it. EU institutions are central. NGOs are very important for transmitting its messages to the EU institutions, but at the same time try to sort of be a proxy for citizens. But again, citizens are outside this semiotic system and may not be represented the way they would like to. Next slide, please. So, and this is sort of my conclusions. I actually don't like these conclusions as much as I would have hoped, because I was reflecting more. Really, what I think I want to argue is that, yes, it's true. Citizens participated in EU MHG via NGOs, but NGOs do not equal citizen representatives. They at best, when they are really responsible, they do not claim to be representatives of citizens. They do claim to communicate and be a sort of transit for citizen ideas. So EU MHG really kind of imposed obstacles to informed and politically effective citizen input. And again, the EU MHG was not renewed in the 2018 Commission budget. I think what I really want to say is this was a case of an example of soft law and its limitations for sort of breaching that democratic deficit. And usually democratic deficit is talked about in terms of voting, right? And citizen voting. But this is another form in which there's a deficit to citizen actual engagement with the EU. And then also, of course, the other important conclusion that I reached was that the whole focus, the focus on mental health disorders, and rather than focusing on mental health as a public health question, is very important. I don't see that changing. It fits too nicely, the latter approach, the one that eventually evolved, fits too nicely within EU goals for market optimization, as Fleer calls it. So those were my main conclusions.
Okay, thank you very much, Kristin. So we have 2 speakers left now, I believe. Is that right, Ellie?
Yeah, yeah.
I think first we're hearing from Professor Scott Greer from Michigan. Very happy that could join us this afternoon. And then finally, Dr. Diletta Danieli from University of Verona. So first over to Scott, please.
Hi. No slides because I hadn't realized I would be crashing in as a speaker. So I'll just try and say a couple of words that might make the conversation more fun. And it was really fun to do kind of a big think piece, and I hope that that compensates for all the interesting things that I've learned from all the other participants in the seminar and in the special issue. So thanks very much for organizing it and bringing it all the way through to fruition, Ellie and Mary. What I did in the paper was draw on a study I just published of a collective study that I edited of comparative federations and how different federations organize their social policy, how they pay for things, how they deliver things, and how programs layer on top of constitutional law to create the real existing federation. There's a strong institutionalist bias and a strong legalist bias that is undermined when you realize that in every federation, the structure of how money and policy are built constitute a really big, solid obstacle to a lot of kinds of changes you might imagine if you only read the Constitution. So we went through a whole lot of federations, all the OECD federations by a generous definition of federalism, so including, for example, the United Kingdom. And one thing really stood out. They're not that different. They all have essentially the same basic default structure for the finance and organization of healthcare and a number of other social policy areas, which is, to my dismay, the one that economists recommend, because I didn't go into political science to find that economists are normatively or descriptively accurate about politics. So this hurt, but I've come to terms with it. Essentially, you should pool risks, finance at the biggest level possible, and deliver at the lowest level possible. So you should have a substantial component of national fundraising for healthcare and egalitarian distribution of money for healthcare at the biggest level possible, which in Europe is the member state, and then you deliver at the lower level. Regulation is relatively ineffective, actually, within the federations. It's not the main way that they get people to do things. Money is. Now, you don't have to know much about the European Union to realize that this bears no resemblance to the European Union, right? The originality of the European Union is that it directly does very little. While structural funds loom large in some countries' budgets, they're still an absolute drop in the bucket compared to the costs of running a health system. There's very, very little pooling of risk or financing at the European Union level, which politically, as Tomislav Sokol and I wrote ages ago, is predictable because in a continent with enormous disparities between countries, you wouldn't expect a lot of support for redistribution from the Luxembourgs and the Germanys and so forth. That said, what is the stability of a system that appears to defy the law of gravity that otherwise characterizes countries as different as Brazil and Australia or the United States and Mexico? Well, the risk in the EU is that in order to deal with its own internal instability, it doubled down on regulation. And this was particularly prominent after the 2008 financial crisis. And it made more and more efforts to make countries look after themselves. This is economic nonsense because the main problem that EU member states have is the internal imbalances within the EU. Basically, EU member states tend to think like small open economies, which is fine, except what they're doing is jointly governing a large closed economy. It does make sense if what the real goal was to promote austerity, which fits with the ideology of the governments that were mostly controlling European politics in the decade after 2008. Comparative federalism, though, suggests that it's still not stable. Ellie and I worked on how it was being undermined even before the coronavirus crisis. But here's the future that worried me, and I think bears reflection, given that we are going to be seeing a reconstruction of the European Union influence on the finance and delivery of health and other social services soon. The future that worries me is Italy. At the time of Italian reunification, there were two pronouncedly different but roughly equally wealthy economies in the north and the south. They ran very differently, however, the basic inputs, outputs, activities, organizations, so equally wealthy but very different economies. The effect of Italian reunification, which was of course driven by the Kingdom of the Two Sicilies, was to impose one structure, a structure that we would recognize from contemporary European politics. Very liberal with a small L, very hard currency, very focused on market discipline and the state as a maker of rules as against the use of the currency, for example, to smooth out economic malfunction. Over time, it turned out that this was fine for northern Italy, which went on the course to become one of the richest places in the world, and it was a disaster for southern Italy, which became a function, couldn't function, and also didn't have the resources to restructure its economy. How do you maintain this increasingly unstable liberal system? You buy off the political elites by giving them money. The political elites use the money to build clientelistic, corrupt systems. I've painted the picture of how liberal rule of law and hard currency misapplied from Italian reunification onward gave us precisely the corrupt sinkhole that is the Mezzogiorno today. The worry is that they were replaying this on the scale of the entire continent, using structural funds and other favors to buy off the likes of Viktor Orban as they cemented their position in increasingly non-viable economies within the European Union's broader rule of law and monetary system. So that was the Italian history essay, but the point it made is that there's a reason no viable existing federation depends on regulation with so little transfer of money for social services. And Italy shows that this doesn't mean the EU breaks up. It just could mean that the EU ends up with a gigantic Mezzogiorno stretching from Portugal all the way around to Poland. Fortunately, the coronavirus hit just about when the paper was presented, and we now see what might be the Hamiltonian moment, the moment of shared EU debt that is not conditional and is not easily directed into that kind of use, which might mean that we actually see some steps towards something I didn't think I'd see when I wrote the paper, which is joint EU financing of its member states in a way akin to every existing wealthy federation. I hope that was a nice contrast to all the actual useful information you learned from everybody else, and thank you for letting me crash.
That was great. Thank you very much, Scott. So I hope you're still able to join us for the discussion afterwards as well. Okay, so our final panel member today is Dr. Diletta Danieli from Verona University. So it's a bit of a return to a competitional theme, this time looking at excessive pricing in the pharmaceutical industry. So Diletta, the floor is yours. And I have your slide here.
Thank you. Thank you very much, Mary, and good afternoon to you all. and thank you for inviting me to this panel discussion, and also before, of course, to the Edinburgh workshop. It seems like a lifetime ago, but actually it was really, really exciting. So now really back again to competition law. As you can see in this very brief slide, I just recap the main points of the paper, just to have an overview. But the actual topic is, as you can see, the excessive pricing conduct in the pharmaceutical industry. And basically, these pricing conducts regard those price hikes that have been observed, especially in relation to off-patent drugs. So this is the main background that I looked into, actually starting from a case study. So I looked at the practical examples that came through, and basically from Italy and from the UK, they were the most prominent examples. And actually, these two cases shared also some factual similarities. So they were very useful also to compare the convergences and divergences of the two approaches of the competition law authorities from Italy and the UK, of course. So I will not go too much into the details, the factual details of these cases. It would take too much time, and I will just focus on a couple of facts that are I find important to have the general background of those cases. So actually, both cases concern drugs that have long been developed and, as I said, were already gone off patent. So this means that the substantial price increase that these pharmaceutical companies charged could not find justification in a sort of recoupment of R&D investment. So in this case, the strategies that the pharmaceutical companies put in place actually exploited a sort of situation of actual lack of competition in the respective relevant markets. And this is really the main factual point. So this situation of near absence of competition actually led to a significant price inelasticity in demand of the drugs concerned, and this made it possible for the pharmaceutical companies, as I said, to actually charge excessive prices regarding these drugs. Actually, I just made this point regarding the hurdles of the competition law scrutiny, because my main point in the paper was actually to try to establish whether the competition law scrutiny is justified into these pricing conduct. This begs the question because actually in this case the relevant competition law provision is Article 102 of the Treaty of the Functioning of the European Union, which of course has a specific provision regarding unfair practice, but it's very debated whether these competition law provision should be enforced, because there is a sort of pro and anti competition law enforcement stance regarding excessive pricing, and so that's why these conducts were really interesting to deepen, because of these problematic competition law enforcement regarding unfair prices, and in particular Article 102 in this regard. Also because the only relevant guidance of the Court of Justice in this regard was really dating back to 1978. So really in this regard, the Court of Justice is not much of help, or actually it is of help, but sort of telling the test that should be employed in these cases for the assessment of the excessive pricing conduct, which is based on a two-pronged test. On the one hand, the first prong should concern the excessiveness of the price in question, and then after the excessiveness has been established, the second prong of this test is to examine the unfairness of these prices. So in this United Brand test of the Court of Justice, there was this step spelled out. The problem regarding the pharmaceutical industry is, again, that on the one hand, these two cases pointed out to a situation where the price increases were extremely striking. So it was actually, so to say, easy to find, to establish these two levels. On the one hand, the price excessiveness, and on the other hand, the price unfairness. But actually, as I mentioned briefly in the slide, these hurdles for the competition law scrutiny, it's not that it is usually so. So these two cases were, as I said, particularly striking, and it was sort of easy for the competition law enforcer to establish, especially the price excessiveness, because the relationship between price and cost was very disproportionate, and so they had an easy way, so to say, to establish the anti-competitive conduct in those cases. So this made me think, whether, as I mentioned at the beginning, the competition law enforcement should be justified in these instances, and to what extent should be justified. And actually, my reflection, which I also argued, of course, in the paper, point me to have a more of a prospective look, as I mentioned in the slide, because in my opinion, of course, there is this sort of overlapping between competition law enforcement regarding this kind of contact and the regulation. So the regulatory framework that, of course, in the pharmaceutical industry is particularly extensive, as we all know. So there is this kind of overlapping between, on the one hand, competition, and on the other hand, regulation, which actually should have, of course, very different scopes of intervention. But regarding this kind of conduct, it seems to me they actually merge their respective objectives. And so I thought that it could be, a good case study to sort of observe a kind of transformation of competition law enforcement in a sort of a quasi-regulatory instrument for the competition law enforcer that could maybe spill over also to the regulatory framework, and maybe offer also some kind of benchmarks and some kind of example to take from. So this was my conclusion in the paper. So this sort of mix between the scopes of intervention between the competition law and regulation, to some extent, of course, could be also beneficial to one another. So this was, of course, my humble conclusion in the paper. So thank you very much again for your attention, and I look forward to the discussion.
Okay, thank you very much, Diletta, for rounding off the presentations for the panel discussion. Just before we go to the question and answer session, I just wanted to extend mine and Ellie's thanks to everyone who's joined us today, but also obviously to the British Academy for generously funding this project, and to the support we had in putting together the special issue with health economics, policy and law. So our thanks to Dr. Adam Oliver, Professor Tamara Harvey of City University, and Dr. Jan Kees Helderman of Radboud University in Nijmegen. Okay, so with that, I'm going to stop sharing my screen and stop the recording.